So a case challenging the NFA and its restrictions on SBRs is now in front of the Supreme Court. It's going to head to conference. And in this case, the Trump DOJ continues to respond in a very interesting way. So let's talk about what is happening in this critical NFA and SBR challenge. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that, of course, is to simply subscribe to the channel. You can also double check to make sure YouTube is not unsubscribed to you. They love to do that on two-way channels. And I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. When it comes to self-defense protection, in my opinion, AOR is in a league of their own. They're backed by an actual law firm, Attorneys for Freedom, so they can help you in self-defense incidents that maybe other companies could not. And one of the really cool things about AOR is they're always expanding their benefits and they're always trying to improve upon their program. So if you're interested, check them out using the links down below. If you use my code ARMEDSCHOLAR, you can get $50 off of an individual plan or $25 off of a family plan. And I highly recommend that you sign up this year to lock in your price because next year the price is going to increase. As I mentioned in the intro, in this video, we're going to be talking about a very important NFA challenge that is now in front of the Supreme Court. This is a case called U.S. versus Rush, and it's a challenge to the NFA and its SBR restrictions. This challenge asks for the Supreme Court to find that the NFA's restrictions are unconstitutional under the Second Amendment. Now, this petition also focuses on the Supreme Court finally needing to step in to correct all these lower courts and the confusion and outright defiance and the whole analysis that's going wrong at the lower court level about what type of arms are protected by the Second Amendment. Now, in this case, the Trump administration originally sent a notice to the Supreme Court waiving their response to the petition. They said that they were not going to respond to this case unless the Supreme Court ordered them to. Well, the Supreme Court recently ordered that the Trump DOJ needed to respond to this case, and the Trump DOJ finally filed their response. In the response, the Trump DOJ argues that the Supreme Court should actually deny review to this case because they believe that the NFA has at least some circumstances in which it's valid and does not violate the Second Amendment. They argue that SBRs are dangerous and unusual weapons that can be restricted by the government, and they say that also this challenge fails as a facial challenge. Now, also interestingly, they argue that the underlying question on whether SBRs are arms and therefore protected by the Second Amendment is a question that should be answered in a different challenge. They argue that instead of taking up an NFA and SBR challenge, the Supreme Court needs to take up a state AR-15 ban to further outline this topic and determine what are actual arms under the Second Amendment. Now, in this case, back in February of 2022, a police officer saw that Mr. Rush, who did not have a license and it was revoked, he was actually pulling into a driveway. He had his truck. He pulled into a driveway, walked across the street, and went into a courthouse for a court appearance. Now, after leaving the courthouse, he walked back across the street, went into an apartment complex, and then about an hour later, Mr. Rush's sister actually left the apartment. She left the complex, got into the truck, and drove away. The officer then decided to stop the sister in the truck, and she actually had the sister call Mr. Rush. And on the phone call with the police officer, Mr. Rush admitted that he actually did drive the truck, to that location without a license, and he said that he would agree to come out and actually speak with the police officer. Now, while this was happening, the police officer was also looking into the vehicle, and he noticed that he saw maybe some marijuana in the center console. And because of that, the police officer began to search the truck. Now, Mr. Rush, at that same time when the search was starting, arrived at the location. He walked up to the truck, and then he actually opened one of the truck's doors and then reached for an object on the floorboard. Now, after a brief struggle, the officer actually handcuffed Mr. Rush. And then after they searched the vehicle, they uncovered that there was an SBR at that location in the floorboard. Mr. Rush later admitted that he intended to actually grab the rifle and then take off running. And because of this, Mr. Rush was charged with possessing an illegal SBR in violation of the NFA. Now, Mr. Rush argued that the NFA's registration and restrictions actually infringe upon the Second Amendment, and therefore this charge should be dropped against him. Now, the district court on review actually denied his motion, concluding that SBRs are dangerous and unusual firearms, and therefore they are not protected arms under the Second Amendment. This was then appealed up to the Seventh Circuit, who on review affirmed that lower court ruling. Because of this, Mr. Rush has now filed a petition to the United States Supreme Court asking for them to reverse that lower court ruling and find that the NFA and its SBR restrictions do in fact violate the Second Amendment, and he asked for them to analyze this under Bruin, Rahimi, Heller, and McDonald. Now, Mr. Rush is actually supported by the NRA, who's helping to file this lawsuit on his behalf. And in their petition, the NRA argues that since the Supreme Court issued Bruin, courts across the country have struggled to answer the many questions resulting from the court's new analytical framework. In particular, the debate as to what constitutes a bearable arm covered by the Second Amendment has revitalized relevance. So one of the interesting things to note about this case is that although it deals with SBRs and the arbitrary restrictions on those items, the challenge also is a broader challenge, and it's asking for the Supreme Court to address a broader issue and clarify what are covered arms, what are protected arms under the text of the Second Amendment. And this could impact other state bans on rifles, other state bans on magazines, and really identify what are protected arms. Well, the Trump administration recently filed the response, and first they argued that the petition should be denied because the NFA is facially constitutional. They argued that there is some valid application for the NFA in the Second Amendment context, and therefore it survives a facial challenge. They also argue heavily that SBRs and these types of arms or these types of firearms are dangerous and unusual, and therefore they are not afforded two-way protections. But more importantly, they also argue that this case is not the proper vehicle for reviewing and deciding what arms are protected by the Second Amendment. They argue instead that the Supreme Court should take up a state rifle ban case to answer that question and to further flush out that issue. The Trump DOJ states that he instead asked this court to grant cert to resolve a variety of other analytical issues, such as the meaning of the word arm in the Second Amendment. Some of those questions that petitioner raises may well warrant review in an appropriate case. However, the Trump DOJ states that this case would be a poor vehicle for addressing those issues. Other types of cases, for instance, cases involving state laws banning AR-15s, would provide better vehicles for clarifying the appropriate framework for discerning what types of arms the Second Amendment protects. Based on this, the Trump DOJ asked for the Supreme Court to deny review to this SBR NFA challenge. Now, this is an interesting approach taken by the Trump administration. I anticipated that they would still argue against the petition. They would argue for a denial in this case, and they would argue for the constitutionality of the NFA. We've seen them do that at multiple levels at different circuit courts. We've seen them do that also at the Supreme Court level in the past. However, it seems like that's what they are going to continue to do when it comes to the NFA and GCA. However, for them to argue that the Second Amendment arms question is important and that the Supreme Court should take a different case to address that issue is a little surprising. If that's the case, I would be interested to see how the United States government files, amicus briefs maybe in other cases that are pending in front of the Supreme Court dealing with that very issue, like the Vermontes versus Cook County rifle ban that's coming out of Cook County there in Illinois. That's one of those cases that deals with a rifle ban that's seeking Supreme Court review. So if the Trump DOJ really believes that this question needs to be answered, I would hope that they would actually support that challenge that is also being pushed at the Supreme Court level. We've seen the Trump DOJ already do some similar things when it comes to the Seventh Circuit PICA challenges, and they have joined oral arguments in some of those cases, and they've also recently supported a challenge out of the Third Circuit. Of course, I would love to see them say that the NFA is unconstitutional, that these restrictions are unconstitutional, especially in light right now that we have a $0 tax that's going to take effect on these NFA items. But as of right now, the Trump administration continues to argue for the constitutionality of the NFA. And in this case, they're arguing for the Supreme Court to deny review of this challenge and take up the arms ban question in a different case, maybe like a state rifle ban. And as of right now, this case is going to head to conference. Right now, it's scheduled for potentially November 14th. So it could happen next month, November 14th. And I think the one after that, the conference date after that is November 21st. So we're going to see, how does it develop. The petitioners here still have an opportunity to file a response to what the Trump administration said. And so they have one more opportunity to push the Supreme Court to grant review to this challenge. So again, a very important challenge that is now moving forward at the Supreme Court level. As it develops more, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that, of course, is to subscribe to the channel. That helps the channel to grow. Also, you can check out my website, ARMEDSCHOLAR.com. Over there, we have a lot for you guys. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.